The case is otherwise ready. Why?
Notice is been issued to the respondent.
They have appeared.
Some of the respondents have appeared.
Who has not appeared?
Respondent 3497 refused not followed. Respondent 710 to 16 and 17 refused notice.
Refuse मतलब service ना?
Yes, he has deemed to service.
Deemed service होगा तो सुनेंगे. Deemed service हो चुका होगा, service complete होगा, record आ चुका होगा तो सुनेंगे. ऐसे नहीं statement करेंगे.
This may be
Well, आज तो कितना बजे?
12:45 में भी है सर 12:13 को
कल इसको supplementary में करेंगे.
Notice serial 33 matter. Final this program matter. Till today test किया है.
आप तो तैयार है ना? कल करेंगे. कल करेंगे. अदर साइड कौन है? सर्विस सब कंप्लीट है ना?
सर्विस कंप्लीट है. फाइनल डिस्पोजल
सेकंड अपील है.
सेकंड
क्या सब्सटेंशियल क्वेश्चन है?
ये जनरली के ऊपर है इंग्लिश में.
हाँ?
जनरली के ऊपर है कि उस भाषा में से लोग बिलोंग करते हैं.
देखते हैं कल क्या है. आज तो पॉसिबल नहीं है. नहीं कल ऐसे बिना सुने हम कोई इंट्री मॉडल एक्सटेंड नहीं करेंगे. और 75 क्या है?
70 और 25 भी है.
ऐसे एडजस्टमेंट नहीं होता है. सुबह सुबह टाइम मत वेस्ट करो.
Item number 3 से आने permitted.
Item number 3
ये number 1206.
समझ गए? The learned counsel for the petitioner seeks permission to withdraw his bail application. This petition is dismissed as withdrawn.
Serial number 5, I will be allowed to withdraw.
Serial number 5 of main
Daily
list.
was listed.
Serial number 5, daily cause list. The counsel for the petitioner seeks permission to withdraw this petition. Dismissed as withdrawn.
साइन कर लीजिए.
Item number 51, 52, Lordship. On last occasion, the senior discussion the paper mentioned this matter. However, it could argue that
What is 50 and 51?
connected matters. Second appeal, 153 of 18, and one is of 23, 154 of 20.
So what is the urgency?
There is an interim order there.
Interim order is expiring today.
Yes. Yes. It was extended on till today.
Where is the other side?
We have informed Mr. Nikhil Rajan and Mr. Adi Banerjee sir and
आपका मैसेज है.
Yes, madam. Let's go to the phone.
क्या हुआ नोटिस का?
Madam, no, I think that Mr. Nikhil Ranjan has to file it. He has filed it. I mean, second case within interim order is still today.
What about the other case has got matured?
First case has not been matured.
Why? Who has not appeared?
Some of the respondents
As a
who
some
are,
of the respondents.
some have died. He has filed IR. I have told him to come, but he might be in some coma. My case is
12:15 में आइए देखते हैं. Inform him. चलिए कॉल करिए.
From the supplementary list.
From this list. Serial 50 of the arrest and execution is
It's not possible to do. We should have done next time.
From the supplementary list under heading for fresh filing, item 1 BA 1365 of 2016.
of the arguing counsel is not
सप्लीमेंट्री लिस्ट से मैटर है. कल कहाँ पे? आप ही के कहने से ना आ जाया है.
तबियत खराब
अभी अचानक तबीयत खराब हो गई. क्या हो गया? कल आपके कहने से आया है ना? फिर नॉट टुडे चाहिए. कल नहीं आइएगा तो डिसमिस कर देंगे। आपके सीनियर नहीं आए तो खुद तैयार होकर आ जाइएगा, नहीं तो डिसमिस कर देंगे, हम बता देंगे, नॉट प्रेस्ड कर देंगे, काउंसिल फॉर द पिटिशनर ऐसे लिख देंगे, नॉट रेडी टू आर्ग्यू द केस। कौन थे, कल कौन अपीयर हुए थे? मिस्टर अजीत अजीत कुमार
सिंह
नहीं बता रहे, कोर्ट नहीं आए हैं, कहीं कोई अपीयरेंस नहीं ना है रिकॉर्डेड? BA number 1365 of 2026. The matter was listed yesterday. At the request of the counsel for the petitioner, the matter has been posted today. Today again, the petitioner is seeking adjournment and submits that the matter be posted tomorrow. By way of last indulgence, post this case tomorrow. Pass over not today कुछ मत मानिएगा, बस आज आ जाइए।
Item 2, BA 1392 of 2026.
Yes, petitioner.
Lordship, in serial number 2, I may be permitted to withdraw this bail application, Your Lordship.
Are you there in the High Court?
Sorry, Your Lordship, you are not audible. Your voice is not audible, Your Lordship.
The counsel for the petitioner has joined online. He seeks permission to withdraw this petition. This petition is dismissed as withdrawn.
The heading for admission, item 4, BA 12068 of 2025.
Where is the petition? Pass over. ऐसे पास ओवर तो आज क्या ही होता है? Petitioner absent. Counsel for the state is present. Post over.
From daily list, under the heading for fresh filing admission, item 1, BA 1440 of 2026.
Yes, please.
Custody since 19 July 2024, about 21, under section 302 of IPC. The Constitution state relies on the statement of an informant who was not an eyewitness. She claims to have been informed by a third party named Sunil Mitra. The evidence is currently hearsay in nature. Provided murder does not mention any motive for the murder or the recovery of the weapon as it is in the whole
For this time. State to find out that. Let this order be communicated to facts. Post this case on 7th of April.
Item 2, BA 1442 of 2026.
Also, FIR is registered to the office municipal administration 302 IPC. The relevant portion of the FIR is based on the 16 laws of yes.
Page number?
16 laws.
Yes.
सभी ने निवेदन को कहना है कि मैं मनोज मिश्रा और 50 वर्ष
का रहने वाला हूँ। दिनांक 27/12/2023 को सुबह करीब 7 बजे दूरभाष के माध्यम से ग्रामीणों के द्वारा सूचना मिली कि मेरी मां फोटो देवी को मेरा भतीजा अरविंद मिश्रा उम्र करीब 30 वर्ष पिता स्वर्गीय पंकज मिश्रा ने डंडे से बुरी तरह मारपीट कर हत्या कर दिया है, जिसके बाद ग्रामीण मुखिया एवं अन्य लोगों से इस बात की जानकारी अच्छे से ली तो पता चला कि मेरा भतीजा अरविंद मिश्रा प्रातः मेरी मां फोटो देवी को जमीन बेचने को लेकर मारपीट करते रहता था। दिनांक 27/12/2023 को रात्रि करीब 1 बजे डंडे से मारपीट कर हत्या कर दिया है और घर से फरार हो गया है। सारी जानकारी मिलने पर मैं तुरंत स्थित होकर मेहता थाना को दिया और निवेदन किया कि इस घटना की तहकीकात अच्छे से करें। इसके बाद मैं तुरंत घर आने के लिए ट्रेन पकड़कर चल दिए। पुनः मुझे दिन में मेरे गोतिया के सुबोध मिश्रा उम्र करीब 81 वर्ष पिता के द्वारा सूचना मिला कि पुलिस आई है और आपकी मां को पोस्टमार्टम कराने की सदर पर गोटा भेज रही है, जिसके बाद मैं आज अपने घर प्रतापपुर आकर इस घटना के संबंध में थाना में लिखित आवेदन दे रहा हूँ। Several witnesses have been examined. One of the witnesses at page number 21, who is the doctor of the said village, has stated Lordship. May I read Lordship? घटना दिनांक 26/12/2023 की है। मैं अपने गांव में छोटा मोटा प्राथमिक इलाज लोगों को इलाज होने पर करता हूँ। घटना की
How many witnesses have been examined?
Three witnesses. And also this doctor, he is a doctor Lordship. He said कि घटना के दिन जो फोटो देवी है वो गिर गई थी, उनके हाथ में चोट लगा था। उसका इलाज के लिए जो एक्यूज है पिटिशनर वो खुद जाकर डॉक्टर को लेकर आया था और डॉक्टर उनका इलाज किया था, बोला था कि ये सीरियस है, इनको फर्दर इलाज के लिए रेफर किया गया था। ये कर है तो और एक जो पोस्टमार्टम में जो इंजरी आया वो भी वही हाथ का इंजरी है जिसके कारण उसका डेथ हुआ है। तो जो PW3 उनके स्टेटमेंट से क्लियर है कि हम I am not the silent Lordship. She has fallen down and she was 65 to 70 years of age Lordship.
65 के एज में लोग मर जाते हैं। 65 को हम ओल्ड एज नहीं मानते।
नहीं और Lordship I have studied since 29/12/2023. 29/12/2023.
आपको क्या बोलना?
Under me, several injuries
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since 29/12/2023 and the doctor has been examined in the trial and he has stated that the mother of the petitioner had expired due to injury caused in her hand. He submits that in view of the evidence of the doctor, there is no likelihood of conviction of the petitioner. यही आपका कहना है? Till today, how many witnesses have been examined?
3.
With the 19/10/25 का है। उसके बाद कोई witness examined नहीं हुआ। We have submitted that till today 3 witnesses have been examined out of 6 prosecution witnesses. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner and the postmortem report reveals that there were several injuries. कोई बात नहीं।
Postmortem का वहाँ पे
After hearing the learned counsel for the parties, this court finds that the bail application of the petitioner was earlier rejected in BA number 7766 of 2024 by order dated 29/11/2024, but none of the counsel for the parties have pointed out this fact to this court during the course of hearing. The bail application of the petitioner was rejected on merits and the trial is in progress. Accordingly, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure prompt production of witnesses so that the trial is taken to a logical end. Counsel for the state is directed to communicate this order to the concerned authority to ensure compliance. अच्छी बात है आपका ये. हम इतना देर से 10 मिनट से इसीलिए सुन रहे हैं. आपके मुंह से निकलता तो सही, earlier rejected है. Dismissed. Gross suppression on behalf of both of you. I have recorded it in the order. आप लोग को कोई responsibility नहीं है. चलिए.
Item 3 DT.11.03.2026.
Yes.
माइनर डॉक्टर को पहला पुस्तक साथ में कर दी and the victim has been examined and even the informant has been examined the trial wherein she has been stated that is 17 and she could watch and the relevant
Case 17.
yes also and the relevant question is
Just a moment. Yes.
the relevant question in the next case para 9 yeah
This is page 17 is not the victim.
that is informant
Informant. I'm talking about the victim.
victim का जो आया है report में नहीं लिखा है report certified copy of report से एग्जाम
तो आप इसको लगाए क्यों?
जो अभी कुछ दिन पहले मुझे I was and she has stated that she was 18 years at the time of this incident and वो खुद से अपनी मर्जी से की
और जो स्कूल का सर्टिफिकेट है उसका क्या करें? It has to be thrown in dustbin.
no not पर relevant question पढ़ लेते हो
पढ़िए ना. क्लास 10 का सर्टिफिकेट है ना?
हाँ
Showing her date of birth as 1/1/2009.
नहीं जो इसमें सर para 9 में अगर informant का examination लेता है
Examination से क्या होगा? Class 10 का सर्टिफिकेट is not sufficient.
it is
Then
sufficient but not sufficient. She has stated herself that her age was 18 years at the time of the accident.
for the learned counsel appearing on
And
behalf
they have
of the
married
parties.
rights not also. एक बार victim का testimony देख लेते हैं.
Only one witness,
जो informant and victim हैं.
only one examined out of 9 witnesses. Huh? How many witnesses have been examined?
No, right now two also. Victim also has been examined. And she has given statement on support of the testimony. Can you see the pattern of the wrong?
How many more witnesses are to be examined? For the learned counsel's opinion on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 8/7/2025 and he is 25 years of age. And the victim has been examined before the court, who has stated that she was having love affair with the petitioner, and her marriage was fixed in another place by the family members, and therefore she eloped with the petitioner and solemnized marriage in Chennai. And the petitioner established physical relation with her many times. The learned counsel submits that the petitioner has deposed that she was more than, the victim has deposed before the court that she was more than 18 years of age at the time of occurrence. The learned counsel for the state has opposed the prayer and has submitted that as per class 10 of secondary examination of 2025, the date of birth of the victim is 1/1/2009, and therefore the victim was minor. कब से आप कस्टडी में? 8/7? यहाँ पे ट्रायल चल रहा है. That's true. Considering the arguments of the learned counsel for the petitioner and the fact that the victim has already been examined before the court, who herself has stated that she eloped with the petitioner, and considering the custody of the petitioner since 8/7/2025, the petitioner is directed to the enlargement court. भाग गया दोनों, क्या करेंगे? कुछ कर सकते हैं हम सोसाइटी में? बेल ही तो है, कन्विक्शन तो इनका तय है. चलिए.
Item 4.11.04.2026.
FIR registered under section 103 of the BNS, corresponding 302 of the ANS. Altogether 5 persons are named in the first information. The informant is not an eyewitness. My name is transferred on the basis of suspicion. This number 9 is the FIR. Body of the deceased is found from the well.
केस डायरी कम,
Yes, sir.
कोई एंटीसीडेंट का कोई काम नहीं है. एंटीसीडेंट रिपोर्ट की बात है. 7th April. 7th April. चार्जशीट हो गया ना आपका?
हाँ, yes.
तो कोर्ट से ही आएगा केस डायरी.
Item 6, DA 1499 of 2026.
was filed on mere suspicion.
It's at the advanced stage. Just 2 witnesses have to be examined.
Case diary will be called.
Not required. DA number
Case
1499 of
diary
2026.
will be called.
Not required. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been advanced stage of trial में 2 witness बाकी हैं. अभी 2 डेट में आपका एग्जामिनेशन करा देंगे. You should be happy with that. कोई बात नहीं.
Status report मंगवा रहे हैं.
Not required. It is mentioned. गलत लिखा है इधर.
रिकॉर्ड में ले आते एविडेंसेस.
Not required. 4/12/25 को 2 विटनेस बाकी थे. हो सकता है एक और इस बीच एग्जामिन हो.
Case ये डेट दे दिया जाए.
नहीं.
Then I can frame on the.
Madam, please stop. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and he is in custody since
5/3/2020.
since 5/3/2024. The learned counsel for the state has opposed a prayer and has submitted that it was the petitioner who had threatened the son of the informant earlier, and ultimately he was killed. He has also submitted that 8 out of 10 witnesses have already been examined till 4/12/2025, and trial is at the flag end. Only informant and the IO are required to be examined. After hearing the learned counsel for the parties and considering the fact that the trial is at the flag end, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure prompt production of witnesses. He is directed to communicate this order to the concerned authority.
Item 7, DA.11.03 of 2026.
Sorry?
The senior will assist in this case.
Who is the senior?
Mr. Black President.
So,
He is candidate of Black Council license. Next week is.
तो कोई रीजन है आपका क्लाइंट जेल में है और बार काउंसिल इलेक्शन में घूम रहे हैं. एक दिन जेल में भारी है ना. Counsel for the petitioner seeks adjournment. He submits that the arguing counsel is busy in bar council election. कब है election? परसों रख देते. फ्राइडे छुट्टी मना रहे. पोस्ट डे आपको.
Item 8, DA.1.09 of 2026.
This is under section 420 of the rules. Main section is 420, 416, 467. The negation has to be FIR.
Please wait. And counter. File your counter. किसको नोटिस करेंगे?
कंप्लेंट केस है.
कंप्लीट केस.
जी
नहीं.
बाकी कोई कुछ तो नहीं.
उसके बाद इन्वेस्टिगेशन में गया था क्या मैटर?
चार्जशीट हो गया है. पूरा कुछ तो नहीं.
FIR तो वही है.
फॉल्स डॉक्यूमेंट यूज करके इनका एलिगेशन है कि लैंड ट्रांसफर कर दिया है।
बहुत सीरियस बात है ना।
पेमेंट का स्लिप दिए हुए हैं कि हम पे किए हैं पैसा, उसके बाद ट्रांसफर हुआ है और ट्रांसफर भी नहीं हो पाया, पैसा भी दिए, म्यूटेशन कैंसिलेशन के लिए हम ही फाइल किए, म्यूटेशन भी कैंसिल हो गया, जमीन उन्हीं के पास रह गया, मेरा पैसा भी चला गया। जो पेमेंट किए हुए लगाए हुए 28 से 32 पेज नंबर पे है।
आपको कंप्लेनेंट को पार्टी नहीं बनाया, क्यों नोटिस करे? जब एफआईआर हो गया बाकी तो सब सीडी में ही आएगा।
जी
आप काउंटर फाइल करिए।
जी
Item 9, DA1510/2026.
case of cybercrime, it said one mobile, one SIM has been recovered.
सीडी क्रिमिनल एंटीसिडेंट रिपोर्ट काउंटर कैशिट हो गया
Yes,
तो फोन से ही आएगा केस डायरी।
yes,
ठीक है।
that's it.
Item 10, DA1512/2026.
7th अप्रैल का डेट है सब, ये सारे केस डायरी वाले केसेस 7th अप्रैल। यस प्लीज।
Case administrator 376 of the course.
Very serious. Not a case complaint.
There are lots of contradiction.
Maybe.
In the diary.
Maybe. So direct allegation against you. BA number 1/12 of 2026. The learned counsel for the
When the
petitioner
statement was
has submitted that
by CWC
not required.
and by the police.
The counsel for the petition has submitted that the petitioner is in custody since 31/5/2024 and he has been falsely impeached in this case. He has submitted that in the case diary the witnesses have not supported the case. The learned counsel for the state has opposed the claim and has submitted that victim was only 12 to 13 years of age and victim has supported the prosecution case in a statement recorded under section 164 CRPC. Wherein she has stated that she had gone to take ration in the shop and when she was going to the shop, one person came in the tempo and forcibly made her to sit in the tempo and pulled her and taken her away. And at the point of knife, he committed wrong with her. Then somehow she escaped. Considering the serious nature of allegation, this court is not inclined to enlarge the petitioner on bail and reject it.
Item 11, DA1513 of 2026.
The offence is under section 187, 8 and 12 of also. It is said that main accuser, Ujjwal Das, has put only 1 million on the head of the victim. And so far this allegation against the present petitioner, it has also come in her statement also. It is said that he has given shelter in his house. He is the brother-in-law. वो लोग दोनों लव अफेयर में मेरे घर आए, मेरे यहाँ से. In the diary also she has not stated anything in 183 statement against the present petitioner. Already vermilion has been put by Surajlal. There is no allegation of outraging or anything on this. Only we are putting vermilion on her. And Ujjwal Das has been granted bail on the grounds he was a juvenile by the court.
He has stated that he had an active role
That is
for kidnapping and forcibly put vermilion in the girl's body.
that Ujjwal Das that forcibly in the 183 statement you will also make forward that can be verified.
Victim is a minor age 15 years.
15 years, that is. There is no allegation of rape or anything, but only putting vermilion in her. they were in, she had not raised any alarm, Lord. She had traveled for 60 kilometers, Lord, without raising any alarm. They were friends, Lord, of the same age group. And they had come to my house, I am the brother-in-law, mere ghar.
She was taken at gunpoint.
Lord, it is Lord, your married gunpoint, Lord, if married.
Case diary come to file.
Yes.
Item 12 DA1514/2026.
309 of 4 of BNS is 392 of the IPC. There is a case of robbery. There is allegation against unknown person who has swing pistol encounter and taken.
You have been seeing the CCTV.
Yes, well, there is allegation, but in the CCTV footage there is not a photo of the petitioner has been found. Also. Only merely on suspicion, because the last improvement order page 15 may kindly
Counter
see.
case diary and criminal antecedent.
I have no criminal antecedent.
You will see that.
On the consideration of
that
this
counter case diary.
circumstantial evidence,
Counter
there is
case
no
diary.
direct evidence.
काउंटर का जरूरत नहीं है.
This
है.
वही मंगा.
हाँ.
Counter case diary criminal antecedent. 782.
Item 13 BA1515/2026.
Another sections are there. And the irrigation technology is like you will talk with the informant last 1 year. You might not say but he has to make temper and sir put sir medium forward.
वीडियो भी बनाए हैं.
वीडियो बनाए तो WhatsApp पे केवल डाला गया.
काफी है ना. एज कितना है लड़की का?
16.5.
ये वीडियो है.
ABA रिजेक्शन से लेना देना. देखो. Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that after some argument, when this court was not inclined to enlarge the petitioner on bail, the petitioner seeks permission to withdraw this bail application. Dismiss as
Sign कर दीजिए. Item 14 BA1530/2026.
Case diary criminal antecedent counter 782.
Item 15 BA1536/2026.
Please. Yes, please.
The victim has died on the same day of previous beating, and since last 1 year he is in custody. Almost all the witnesses examined
Yes.
except the doctor.
Except one witness is to be examined more.
नहीं, 3 डॉक्टर का आ रहा है चार्जशीट. डॉक्टर
Advanced stage of trial.
yes, that is there.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition has submitted that the petition is in custody since
28 is in custody, but paragraph written 18/12/24.
18/12/2024 and has submitted that the petition has been falsely implicated in this case. However, during the course of hearing, it transpired that the trial is in advanced stage and only a few official witnesses are required to be examined. The Learned Counsel for the state has opposed the prayer and has submitted that there is serious allegation against the petitioner. And the victim was only, victim ka age
16 years.
was only 16 years of age. After hearing the counsel for the parties and considering the serious nature of allegation and the fact that the trial is at advanced stage, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the concerned authority to ensure compliance.
Almost 14 years. Almost age of the girl.
Age of the girl is almost 14 years.
Item 16, DA1543 of 2016.
In another case also, we were appealing for cyber crime. Is the rising out of same FIR? Case ID, criminal antecedent report, counter activity. 7th April.
Item 17, DA1548 of 2026.
And 164 के बयान में क्या बोला है? Forcibly, you have been, she has fully supported the case against you.
31 तारीख को भी लड़की कहती है कि गायब हुई है। 31 तारीख को शादी के जब घर आ गए उसके बाद केस कर रहे हैं क्योंकि उनके पिताजी के बिना कंसेंट के हम शादी किए हैं, इसीलिए केस रजिस्टर के शादी किए हैं।
ठीक है, बिना कंसेंट के आपने शादी किया?
पिता
बिना पिता के माइनर गर्ल्स वैलिड मैरिज है? कितना एज है उनका?
17 साल है। इसमें मुस्लिम का के अनुसार तो निकाह किया है, रजिस्टर निकाह नामा है।
पॉक्सो नहीं लगता है, क्वाशिंग फाइल कर दीजिए। क्वाशिंग फाइल कर दीजिए, बेस्ट। कैसी क्वाश हो जाएगा? एज पर मुस्लिम लॉ 14 साल की लड़की से शादी कर सकते हैं, इसलिए पॉक्सो नहीं लगता। मुस्लिम लॉ के अनुसार तो 14 साल की से कर सकते हैं।
मेडिकल एग्जामिनेशन भी नहीं हुआ है।
कोई बात नहीं। For the learned counsel for the petitioner, the learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and the petitioner has solemnized marriage with the victim, who is the daughter of the informant, by registration nikah register of Jharkhand government. And when the petitioner went to the police station, and on call when the petitioner went to the police station, the petitioner was arrested. The impugned order reveals that the victim was 17 years of age, and she has supported the case against the petitioner in her statement under section 180 and 183 of BNSS, and clearly stated that the petitioner had kidnapped her and forcibly committed sexual intercourse with her. Considering the serious nature of allegation, this court is not inclined to enlarge the petitioner on bail. It is rejected.
Item 18, DA1574 of 2026.
It's a case under the Arms Act. On the day of occurrence, 5 accused persons were attended on the spot with firearms. They took the name of his possession. Out of 5 accused persons who were found in possession of firearms, they have been granted bail by this honorable court. only on the basis of disclosure of queries on illness.
Case diary counter affidavit criminal antecedent. 7th of April.
Appearance. Item 19, DA.11.03.2026.
Section 302, 326, 338, 307, and 304. The allegation is that the petitioner, who is the husband, while in drunken state, hit her daughter, his wife, as well as burnt her daughter, who is 4 years old.
Yes. For the learned counsel agreeing on behalf of the petitioner, the counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and he is in custody since
9/10/2022.
9/10/2022. After hearing the counsel for the petitioner, this court finds that there is serious allegation against the petitioner that the informant's daughter, Somli Kumari, and other children, that the petitioner had sprinkled kerosene over Somli, aged 4 years. Somli Kumari, aged 4 years, and lit fire. And ultimately, she died. Considering the serious nature of allegation, this court is not inclined to allow the petitioner on bail is rejected. If the counsel for the state has opposed the prayer for bail and has submitted that the manner and the nature of offence is heinous.
Item 20, DA.1598 of 2026.
Offence under section 108(82) and 85 of BNS Blocks and 3(4) of DPA. Corresponding sections are 108 abatement of suicide, death.
What is the date of marriage? You are the husband?
Yes.
What is the date of marriage?
Date of marriage is not
29/4/2025. What is the date of death?
date of death is not
These are purchased.
Where did she die?
she died in her home, in her mother's home, my home.
There is allegation of mental and physical torture.
Lord, there is an allegation of mental torture. Lord, the petitioner was not living in Jharkhand. Lord, he was working abroad. Lord. There was a dispute between the mother-in-law, Lord, and the wife, and a case and the allegation of one extramarital affair has come to the picture, Lord, which has been disputed by the victim, Lord. And she has taken all her jewelry and her household things and went back to her Michael, Lord. And there she committed suicide. Her mother saw her body hanging in the roof, which was
Actually, she had no option.
bolted from inside, Lord. And
Actually, she had no option.
Lord's petitioner was not nowhere involved, no physical torture, Lord, not a single injury on her body, Lord. And he is in custody, Lord, 29/9/2025.
There is a direct allegation against you. You are the husband.
Yes, sir.
Please have some pity. You are responsible for everything.
Lord,
Husband is responsible for anything which happens to his wife.
Lord, in case
If the husband is supporting the wife, nobody can torture him. None. Correct?
Yes, definitely. Lord, one thing has
Not
come.
a case for
One thing has come, Lord, in the case diary, Lord, that there is a angle of, I should not say at this juncture, Lord, but extramarital affair has come. That is
of the lady.
Yes, that is why this has come. Lord. This dispute has arose, and she herself committed suicide.
Let her, let the trial proceed and let us see what comes.
Lord, charge has already been framed, Lord, and there is no point of
Not a case for
Lord. No custodial interrogation is required.
What do you mean no custodial interrogation?
He has remained in custody. Charge has been friendly. He is willing and cooperating. In the
Not
trial.
to the husband. Not to the husband. There is direct allegation against him the FIR.
Because he was not present. That is why I am pressing.
बिना presence के
इसका मदर इन लॉ से हुआ था ये घर गए और ये बात सामने आई और मायके में जाकर
पढ़िए जरा FIR
जी सवेरे निवेदन यह है कि मैं संगोरी मामली उम्र 42 वर्ष पति रंगे शंभू मामली ग्राम नीना बच्चा थाना सुनवा जिला पश्चिम सिंहपुर चाईबासा का रहने वाली हूँ। मुझे कहना है कि मैं अपनी बेटी सरस्वती माली मृतक की शादी 29 अप्रैल 2025 को संधा रीति रिवाज के अनुसार प्रकाश माली उम्र 27 वर्ष पिता प्रभु माली ग्राम थाना सोनवा जिला पश्चिम सिंहपुर चाईबासा के साथ किए थे। उस दिन दोनों अपने घर में ठीक ठाक रहे। इस बीच उसकी सास मंसूरी माली सास एवं बेटी को तंग प्रताड़ित करते लगे और बोलने लगी कि तुम अपना घर कुछ नहीं लाई हो, तुम जैसे रहना है वैसे रहो। इस बात को लेकर अपने पति प्रकाश माली को बताई तो वो भी मेरी बेटी को डांटने लगा और जान से मारने की धमकी देने लगा और बोलने लगा कि मेरी माँ तो ठीक कह रही है, तुम अपना घर से कुछ नहीं लाई हो, जैसे रहना है वैसे रहो। ऐसा ही 2-3 महीना चला। आज से कुछ दिन पहले मेरी बेटी की सास घर के सभी सामान लेकर अपने मायके चली गई और मेरी बेटी बड़ी सास के पास रहकर जीवन यापन करने लगी। दिनांक 20/8/2025 को बेटी सास मंत्री उनके पति प्रकाश माली दोनों से तंग आकर मोबाइल से बात करते हुए अपने घर में जाकर लोहे के पाइप के सहारे आत्महत्या कर ली। मुझे पूरा विश्वास है कि मेरी बेटी की सारी मामली
heard the learned counsel appearing on behalf of the parties. The petitioner is the husband of the victim and was married to the victim on 29th of April 2025 and she committed suicide. It is submitted that she committed suicide in her parental house.
Yes.
In her parental house on 28/2025. The learned counsel has submitted that the petitioner has been falsely implicated in this case. She has committed suicide on her own accord, and in fact she had some extramarital affair. Okay? The learned counsel for the state has opposed the prayer and has submitted that it is direct allegation against the petitioner that on account of demand of dowry, he and his mother used to assault the victim, and ultimately, finding no way out, she left her matrimonial home and committed suicide. This court finds that there is direct allegation against the petitioner, and the victim has died in a short time after marriage. This court is not inclined to enlarge the petitioner on bail.
Under heading for admission, item 21, DA 11.07.03.2025, along with item 22.
Case ID has come.
Yes, sir.
Where is the
And
case
also we
ID?
have the case ID.
Which case are you arguing first?
21.
DA 11.07.3.2.
Yes, sir. In addition.
Let us see the
FIR.
FIR.
Please go ahead. In addition.
Yes, please.
निवेदन पूर्वक कहना है, मैं ऋषिजीत महतो, उम्र सचन सच, पिता सचन सच, आदित्यपुर बिजली बस्ती नियर शिव मंदिर थाना आदित्यपुर सरायकेला का रहने वाला हूँ। मैं दिनांक 3/9/2025 को समय करीब 9:30 बजे रात्रि में अनुपम महतो पिता स्वर्गीय आनंद महतो बताइए जिला सरायकेला में 1 वर्षीय बेटी के बेटे के बड़े पार्टी निमंत्रण में गया था और निमंत्रण में शामिल होकर खाना खाने के पश्चात अपने घर आने के लिए समय 11 बजे रात्रि में उनके घर के सामने अपने स्कूटी संख्या नंबर इतना पर बैठा था। उसी समय 3 स्कूटी सवार राजू गोराय पिटाइए, अनिश टी पिटाइए, पवन उराव, विकास सिंह एंड नवीन कुमार सिंह, हम नवीन कुमार सिंह 5वां नंबर सभी साकी मांझी टोला थाना जिले अभिषेक कुमार पिटाइतना RIT जिला सरायकेला आए और मुझे गाली देते हुए बोला कि स्कूटी हटाओ। इस पर मैंने बोला कि स्कूटी हटा दे रहे हैं, आप लोग क्यों दे रहे हैं, प्यार से बोलो। इस पर सभी ने मुझ पर जानलेवा हमला कर लात मुक्का तथा पत्थर से मारने लगे। उस पर मैं गिर गया और मेरा स्कूटी भी तोड़ दिया तथा बाहर में अन्य बाइक को भी उन लोगों ने तोड़ दिया। यह देखकर पंडाल कर्मी रवि मंडल इतना पिटा इतना मुझे छुड़ाने आए तो उन्हें भी सभी लोगों ने मारपीट कर लात मुक्का तथा पत्थर से मारने लगे। इसी बीच उन लोगों के दोस्त पलटू को अमित प्रसाद सुमित पाटिल आए और मुझे पहला रवि मंडल को ये लोग मारने लगे। जब रवि मंडल बेहोश हो गए तो सभी लोग ने बोला कि साला यह मार गया, इसे छोड़ दो। और राजू गोराय तथा उसका अन्य दोस्त ने रवि मंडल को घसीट कर ले जाने लगा। तब अनूप महतो के घर के से अन्य लोग बाहर निकले और वे सभी छोड़कर भाग गया और उन लोगों को देखकर मैं बचाव करने का प्रयास किया तो उन्हें भी मारपीट कर जान मारने की धमकी दी और टेंट लाइन तोड़ दिए। मारपीट उन लोगों के द्वारा मुझे दाहिने आंख में घाव, दाहिना हाथ, बाई हाथ और पीठ पैर सिर में चोट आई और रवि मंडल के माथे में गंभीर चोट एवं बाई आंख में गंभीर चोट, पेट, सीना और इसका इलाज MGM अस्पताल जमशेदपुर में दोनों ने कराए, जहाँ से रिम्स अस्पताल रांची रेफर किया गया था। परंतु जल्दी ही बेहतर इलाज हेतु हम लोग TMH अस्पताल जमशेदपुर जाकर इलाज किया, जहाँ चिकित्सा महत्वपूर्ण जांच के क्रम में मेरा जबड़ा महीने दर्द से फ्रैक्चर हो गया। तो दिस
और प्रीवियस हर्ट
अब वो जो केस डायरी है उसमें है कि CCTV में आया है कौन है। इफ योर लॉर्डशिप communicate with para 61 CCTV का फुटेज। इस समय दिल्ली बस से सचन सच के प्रचार के 10 बजे तक वीडियो फुटेज रिकॉर्डिंग अवलोकन किया। अवलोकन पर ज्ञात हुआ कि वंदना महतो के घर से पूरब दिशा के स्थित अनुपम महतो के घर पार्टी में आयोजन किया गया था, जिसमें पंडाल बाहर तक लगा है एवं लोगों का आवागमन चल रहा है। इसी बीच करीब 8-9 की संख्या में कुछ लोग आकर मारपीट करते हुए आसपास खड़े मोटरसाइकिल में पत्थर मारकर तोड़ कर रहे हैं एवं पंडाल कर्मी रवि मंडल को बुरी तरह मारपीट कर रहे हैं एवं मार खाने के बाद जब रवि मंडल बेहोशी की स्थिति में चला गया तो वे लोग होश में जमा पानी उसके मुंह पर छींट कर होश में ला रहे हैं एवं पुनः मारपीट कर रहे हैं एवं गहमी से बीच सड़क पर कमर से ऊपर खुले बदन में रवि मंडल का पैर पकड़कर घसीट रहे और अंत में सुनील कुमार पाठक जो इसके प्राथमिकी अभियुक्त है बेसुध पड़े रवि मंडल के छाती पर कूद गया। साथ ही ये सभी टेंट का सामान, पंडाल का कपड़ा, लाइट का सामान, DG जनरेटर तोड़ते दिखाई दिए। वीडियो में मारपीट करते कैद में लोगों में इस कांड के प्राथमिकी अभियुक्त विकास सिंह जो काला रंग का टी-शर्ट एवं जींस पहने हुए हैं, अनिश टी जो भूरा रंग का टी-शर्ट ट्राउजर पहने हुए हैं, सुमित पाठक जो काला रंग का टी शर्ट एवं काला रंग का पैंट पहने हुए, राजीव गोराय पीला रंग का टी शर्ट जींस पहने हुए, अमित प्रसाद उर्फ अमित कुमार जो लाल रंग का टी शर्ट एवं ग्रीन रंग का हाफ पैंट पहने हुए, पलटू उर्फ बोल्टू जो उजला एवं भूरा रंग का चेकदार टी शर्ट एवं ब्लू या काला रंग का पैंट पहने के रूप में प्रकट है। शेष का पहचान अग्रिम अनुसंधान के क्रम में गुप्तचर तैनात की गई है। मैंने सीसीटीवी में जो हम नहीं है। और मुझे इसी में केस डायरी में इंजरी रिपोर्ट है। पहला इंजरी रिपोर्ट जो बना है
ये वाला नेक्स्ट 62
विकास
सीरियल नंबर 22 आ रही है।
नहीं पैरा नंबर 62 भी पढ़े।
अच्छा,
ये भी सीसीटीवी फुटेज से ही रिलेटेड।
पेनड्राइव इतना संहारित वादी विश्वजीत महतो, ये सरायकेला सचिव महतो, दो स्वतंत्र साक्षी सचिव महतो, उम्र 70 इतना, पिता इतना, और सीसीटीवी ऑपरेटर अंकित कुमार महतो, लीडर जिला से समक्ष विधिवत।
That's right. This is also related to that. So your case is that you are not found and
I was not there. My case is this.
Is there any eyewitness to this? Is there any eyewitness to this occurrence?
The informant.
Informant is the eyewitness. Apart from him, informant is the victim and also the eyewitness. Correct?
Previous part का जो section लगा है वो that is being
Previous heart is a bailable offence.
जो लगाए हैं except for your worship 109(2) और 1172 है वो bailable है, केवल 1092 attempt to murder है that is not bailable. Otherwise all rest sections are bailable. और हम बता रहे थे हुजूर की जो इंजरी रिपोर्ट है, there is contradiction in that, but initially वो simple इंजरी का है, subsequently लगता है बाद में बनाया गया है. And my cases I was not there as per the CCTV.
क्या बोलना है आपको?
They are named in the fire.
They are named in that.
Yes.
They are named in that. But CCTV में इनका कुछ आ नहीं रहा. इतना सबका vivid description है.
Para 52 में कह लीजिए case ID.
Para 52.
Yes. विश्वजीत माथुर, इंजरी रिपोर्ट ऑफ विश्वजीत. The injury was previous in nature.
और उसके एक पेज पहले भी देखिए, ये तो 18/9 का है और पेज 31 पे है सिंपल पैरा 89 88
पहले इनका देख, आप बताइए कौन सा पहले आपको?
हाँ मेरा जो पैरा 88 और 89 दोनों जख्मी का जो है, जख्मी विश्वजीत महतो का मेडिकल हुजूर, और इसमें नेक्स्ट पेज में नेचर ऑफ इंजरी सिंपल, ओपिनियन में भी चेंज इफ फर्दर इन्वेस्टिगेशन रिपोर्ट्स आया। इनिशियली सिंपल था और पेज 31 में फिर जख्मी रवि मंडल पैरा 89 इसमें नेचर ऑफ इंजरीज है। अब मेरा केस तो जो सिंपल ओपिनियन, सो हम तो बात थे and I'm in custody since 5/9/2025.
दोनों विक्टिम का बयान तो लिया गया होगा ना? दूसरा विक्टिम का क्या बयान है? इनका स्टेटमेंट। How many days they have remained in hospital? विश्वजीत मुखर्जी का पैरा नंबर 98 में इंजरी रिपोर्ट में ये ग्रीवियस आ रहा है। विश्वजीत 98 पैरा 98।
इनको जो वही तो मैंने कहना कि पहले सिंपल आया एंड सब्सिक्वेंटली ग्रीवियस आया।
ग्रीवियस आया होगा जब फर्दर इन्वेस्टिगेशन हुआ होगा तब ना पता चलेगा फ्रैक्चर है कि नहीं है, इसको पहले तो नहीं पता चलेगा।
लेकिन मेरा तो केस हमने दिया हमारे भी और हम जेल में हैं।
क्या बोलना है इनका सीसीटीवी फुटेज के बारे में?
सीसीटीवी फुटेज पर नहीं दिया, उसमें नहीं किया गया है या बाद में उसमें तो लिखा है इसके बाद इसका देंगे।
बाद में क्या इसका देंगे?
पूरा नहीं किया गया है।
पूरा सीसीटीवी फुटेज का तो पूरा डिस्क्रिप्शन है, सब लाल शर्ट काला शर्ट कौन क्या क्या पहना हुआ है। इनका कहीं कुछ नहीं दिख रहा है, सब मार पीट रहा है, घसीट रहा है, सबका कहानी है। लेकिन सीसीटीवी फुटेज में इनका कहीं कुछ भी जिक्र नहीं, सबका कलर ले दे के सबका आइडेंटिफिकेशन। DA number 11.07.03.2025 of 2025. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that though the petition has been named in the FIR, but in the CCTV footage, the petitioner is nowhere in the picture. She has referred to paragraph 61 of the case diary and has submitted that vivid description of the incident has been mentioned on the basis of CCTV footage, but the petitioner has not been found in that footage. The counsel for the state has opposed the prayer and has submitted that the petitioner is named in the FIR by the victim himself. To this, the counsel for the petitioner has submitted that the petitioner is in custody since 5/9/2025 and charge has already been framed.
No.
तो उसके बाद अनुसंधान में कहाँ लिखे हैं कि उनको पहचाने? Anyways, charge has been framed. Charge sheet must have been submitted. Charge sheet तो हो ही गया होगा ना? 5/9/25 से. Yes, should I say that you have stated that charge sheet has been submitted? आप बताइए.
Charge sheet हो गया होगा. Mr. विकास कुमार है.
The learned counsel has also submitted that charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the aforesaid submission and also the paragraph 61 of the case diary with regard to CCTV footage and the custody of the petitioner since 5/9/2025, the petitioner is entitled to be enlarged on bail. Our next case concern. This is because you have also been identified in the CCTV footage.
Unless I'm identified, but as far as the allegations are concerned, the entire FIR is general and omnibus allegations. There is no specific allegation.
Yeah.
There is no specific allegation of assault against the
DA number 76 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has stated that in the FIR there is general and omnibus allegation.
And there was no intention to achieve this.
Though the petitioner is named in the FIR, he has submitted that there is no intention on the part of the petitioner to commit the offence. The learned counsel for the opposite party has opposed the prayer and has submitted that the victim has suffered grievous injury and he has named the petitioner in the FIR. He has also submitted that on the basis of CCTV footage, the vivid description of the incident has been recorded.
Of this petitioner be standing there.
And he has also been identified.
I was only standing there, but
in the CCTV footage. To this, the counsel for the petitioner has submitted that the petitioner was only standing there. After hearing the learned counsel for the parties and considering the nature of allegation and the fact that the petitioner has been named by the victim and he has also been seen in the CCTV footage in paragraph, as recorded in paragraph number 61 of the case diary, this court is not inclined to enlarge the petitioner on bail.
Item 23, BA 11.11.80 of 2025.
When is the file registration 191.2, 191.3, 192.308, page 16, 17 is the FIR. In this case, all the 18 are granted whether for date which is no DIP.
Case diary.
That's all. That's my kindly see.
Case diary.
That's all the quick. There's no DIP managed.
Acquittal कर देते हैं. I'm asking for the case diary and the counter affidavit. What's your problem about it?
The person who took my name is also granted. I have not named in the FIR.
So I'm asking for the case diary, the criminal antecedent report, and the counter affidavit. You have objection to that also?
No,
I'm posting it on 7th of April. Where is the state council?
Item 24.
Since the counsel for the state is absent, let a copy of this order be communicated to the Office of Learned Advocate General to ensure compliance. आप yes?
Item 24, BA 11.11.81 of 2025.
The FIR is under section 3083, 3084, 111.4, 111.5, and 238 of the BS. The corresponding sections are 385, 386, and 111 has been recently added and section 201 of the BS. The FIR is at page 19.
Case diary counter. Accident.
Item 25, BA 11.904 of 2025.
At the request of the counsel for the petitioner, pose this case. Yeah.
Item 26, BA 141 of 2026.
Yes.
FIR is in the section 406, 419, 386, and 120B of the Indian Penal Code. And before going to the allegations, on 3/1/2026 in trial court, the charge has been filed, madam. Just 3/1/2026 order is there, madam, online order. The FIR is at page number 19.
कैसे अपना पेशेंट
70, 90.
Yes, page number 90.
निवेदन को करना है कि मैं शहाबुद्दीन अहमद उम्र करीब 57 वर्ष, पिता सच एंड सच पूर्व सिंहभूम जमशेदपुर का निवासी हूँ। मैं वर्ष 2008 में कतर खाड़ी देश में रहने कार्य करता हूँ। मेरा भाई सलाउद्दीन अहमद सऊदी अरब में रहकर काम करते हैं। वर्ष 2014-15 से मोहम्मद मुस्तफ़ा वर्तमान सच एंड सच घरेलू चालक के रूप में कार्य करता है। वर्ष 2017 में मोहम्मद मुस्तफ़ा भारत में आकर फिरदौस बानो वर्तमान उम्र सच एंड सच थाना जगन्नाथपुर जिला रांची से शादी कर सऊदी अरब ले गए। मोहम्मद मुस्तफ़ा से मेरी बातचीत होती रहती थी। इसी दरमियान मोहम्मद मुस्तफ़ा जरूरत रहने पर फ्रेंडली लोन भी लिया, लेकिन सभी पैसा वापस कर दिया। इसी बीच मोहम्मद मुस्तफ़ा की बीवी फिरदौस बानो से भी मेरी बातचीत होने लगी। वह हमेशा अपनी गरीबी और मजबूरी सुनाती रहती। जून जुलाई 2017 में फिरदौस बानो अपनी मजबूरी सुनाकर मुझसे 2 लाख रुपए लोन मांगी। मैं उसे 1.5 लाख रुपए भेज दिया और बोला कि मेरी तरफ से सहायता समझो, इसे लौटाने की जरूरत नहीं। करीब 3-4 महीने सऊदी अरब में रहने के बाद फिरदौस बानो वापस भारत आकर घाटशिला में रहने लगे। इसके बाद समय समय पर फिरदौस बानो के मांगने पर 10 से 20 हजार रुपए कई बार भिजवाए। धीरे धीरे मेरे एहसान को अधिकार समझने लगी। तब मैंने उसे पैसा देने से मना कर दिया। कुछ समय शेरघाटी में रहने के बाद वह मोहम्मद मुस्तफ़ा को छोड़ दी और अपनी लड़की तानिया वर्तमान 13 वर्ष को लेकर मोहम्मद सज्जाद आलम नामक युवक पता शेरघाटी के साथ पति पत्नी की तरह रांची में रहने लगे। फिरदौस बानो अक्सर वीडियो कॉल भी करती थी। एक दिन जब मैं कतर में बाथरूम में नहा रहा था, उसी समय उसने वीडियो कॉल किया तो मैं उठाकर उसके बाद में बात करने की कहे। इसी बीच उन्होंने मेरा पासपोर्ट आकार ऊपरी हिस्सा चेहरा से सीना तक का फोटो खींच लिया। उसी दिन से वह उक्त फोटो की बात लेकर मुझे डराने धमकाने लगी। शुरू में मैं नहीं डरा, किंतु वह जब बोली कि थाना में केस कर देंगे तथा तेरा फोटो हर परिवार को भेजते हुए वायरल कर देंगे, तब हम डर गए और उसके कहने अनुसार समय समय पर कई बार मैं लाखों रुपए भेजा। यह सिलसिला कोविड के पहले तक चला। इसके बाद हम अपने मोबाइल नंबर बदल दिए तो कोविड अवधि के करीब 1.5 साल फिरदौस से मेरा कोई संपर्क नहीं हुआ। वीडियो के बाद अचानक वह कहीं से मेरा नया नंबर ढूंढकर हमको कॉल की। हम उसको नजरअंदाज करना चाहे तो वह पहले अपने मजबूरी का रोई। बाद में काम बनता नहीं देख वह थाना जाने की धमकी देने लगी। क्योंकि मेरी लड़की अमेरिका में और मेरा लड़का कतर में सम्मानजनक पद पर सेवारत है, इसीलिए मैं अपनी इज्जत आबरू बचाने के ख्याल से डर गया और फिरदौस इसका फायदा उठाते हुए मुझे ब्लैकमेलिंग करने लगे। इस कार्य में वह अपने मकान मालिक पम्मी और उसके पति छोटू को भी शामिल कर ली और कई बार पम्मी और उसका पति भी मुझसे पैसे और विदेशी सामान कार्गो द्वारा मंगवाई। जब मैं पैसा देने से आनाकानी करता तो फिरदौस मुझे जगन्नाथपुर थाना जाने की धमकी देती तथा दरोगा मनीष यादव एवं दरोगा मिनहाज खान से कई बार फोन नंबर से व्हाट्सएप पर मेरी बातचीत कर रहे। वे पुलिस वाले मुझे 24 घंटे के भीतर जेल भेजने की धमकी दी। तब मैं काफी डर गया और फिरदौस को रुपए भेजने लगा। मैं पुलिस को मैनेज करने और केस में कई कार्रवाई नहीं करने के लिए करीब 5 लाख रुपए फिरदौस को भेजा। इसी बीच फिरदौस के फोन से ही वह एक व्यक्ति से संपर्क करे और बताई कि ये फोटो में जज साहब तेरा सारा केस खत्म कर देंगे। तथा कथित जज साहब नंबर से मेरी बातचीत व्हाट्सएप मैसेज में कराई गई तथा केस खत्म करने के नाम पे 6 लाख रुपए की मांग की गई। मैं 3-3 लाख रुपए कर 2 बार में फिरदौस बानो एवं उसका पति शहजाद आलम के खाते में कुल 6 लाख रुपए भेजे। पैसे देने की थोड़ी देर हो रहा था तो जज साहब बोले कि मेरी बेटी की शादी है, जल्द पैसा भेजो। इसके बाद फिरदौस बानो पति शहजाद आलम, मकान मालिक पम्मी, छोटे फर्जी दरोगा मनीष यादव एवं मिनहाज खान तथा कथित जज साहब
कौन?
मतलब मैं just this is a fictitious story. Why I am saying this? This man who is the complainant had a relationship with the wife of the present petitioner. He is the second husband, that is admitted. And admittedly, the money were transferred to the lady in love and affection. That is there in the WhatsApp chats also, madam. Subsequently, when the complainant was caught for by his wife, he created a story and this because again, if he would be any these are fictitious person just to make the case so serious, madam. Because charge sheet was submitted and subsequently had it been the means fictitious daroga or judge sahab, he would have been brought before the court in trial or he would have been apprehended, but कोई apprehension नहीं है.
There is a bank account transfer in your name also.
Yes.
Why have you taken money?
Madam, initially Firdaus, who is my second, first wife and his second husband, money was transferred into her account. Subsequently, he came to India, and madam, both three of us, he has.
I want to know why have you taken money in your account?
Madam, she has shown me, means the complainant and his brother. And his photos are also there, mother, at page number 48.
You are not answering my question. Why have you taken money in your account?
Mother, that was transferred by his by his account. I have not taken it.
It has been transferred in your account.
Correct.
So
that
you have taken money.
That is admittedly money.
Yes, that is all. Money trail is there
yes,
in your account. Why have you taken money? Why have you taken money? How is the learned counsel appearing on
one more, just mother, if you lordship, just come to page number 48 and 49. Mother, 49 will make it more specific. They three, including myself also, had a good relation. It's not that we have extorted. He has given in love and affection, mother. And my lord, we come to page number, my annexation number 2, my lord. There's a series of chat, my lord, wherein it's not a case of extortion. If page number 42 is perused, very means bottom left, the complainant, my lord, he is proposing in love and affection to the complainant. Then the very next page, my lord, will make the picture clear. Page number 43, my lord. He is writing complainant free हो, then with 5 minutes. फलक कि मालूम है वो आप हमसे मैसेज करते हो, अभी बोल रही थी. क्या ये नहीं हो सकता है? आपकी फ्रेंड ने उसको बता दिया. That means, madam, my wife's friend has intimated complainant's wife, and the dispute started. आपकी फ्रेंड ने उसको बता दिया है. आप खुद पता कर लो. Oh my God. Then, madam, आप 1 मिनट कॉल करें जल्दी. Then, madam, she is writing. पता नहीं भाभी जी क्या सोचेगी, बता देना, हम आपके पैसे के लिए फोर्स कर रहे थे और कुछ नहीं. Now he is saying, my lord, if my wife wants you or something as of, then you tell her that I am forcing off my money which I have given to you. So, my lord, I am just the money was transferred as an aid, my lord. It was not as such. And those sections which have been labeled, my lord, and I'm just under section 406, my lord, there is that talks of entrustment, my lord. There is no entrustment as such. I'll just take 2 minutes of it. 406, my lord, 405. that talks of criminal breach of trust. Whoever
Washing नहीं बहस कर रहे, bail बहस कर रहे. It's a point washing के लिए. Discharge file कर दिया आपने?
I'm ready for trial because that order sheet also have 419 is there, but that is also not maintainable, and 486 extortion to होगा ही.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner. The learned counsel for the state has filed counter affidavit during the court proceedings, which is taken under control. The learned counsel for the petitioner submits that the petitioner is the second husband of
No, God Banu is yes.
the petitioner is the second husband of Firdaus Banu, and as per the FIR, the informant has been giving money time and again to Firdaus Banu. He submits that there was certain relationship between the lady and the informant, and the money was given to her by way of love and affection. He submits that when the relationship came to the light of the petitioner, then the FIR has been instituted, making false allegation against the petitioner. That the petitioner had also extorted money from the informant, along with Firdaus Banu. The learned counsel submits that the petitioner has been falsely implicated in this case, and he has also referred to एक उसमें है ये आपका केस डायरी का पार्ट है.
नहीं, WhatsApp chat we have not a part.
He has also referred to certain WhatsApp chat annexed with the bail application and submits that they are not part of the case diary, but those materials have been has been filed along with the bail application for appreciation of the fact that the lady had relationship with the informant. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner, and the amount has also been taken by the petitioner in his bank account, which has come in para 48 of the case diary and also is mentioned in the interim judgment. After hearing the learned counsel for the parties and considering the nature of allegation, it remains and it is direct allegation against the petitioner that the petitioner had also extorted money from the informant, and this is supported by the transaction of money from the account of the informant in the name of the petitioner in his bank account. In such circumstances, this court is not inclined to enlarge the petitioner on bail constituted.
Item 27, BA1 for 5/2026.
Worship again counsel Mr. Diwakar Jha has to go back to his room because of some emergency where he received call from his wife. So please on this one.
The counsel for the petitioner submits that on account of some emergent situation at home, the admin counsel, Mr. Divakar Jha, has rushed home to seek adjournment. Supposed to monitor.
Appearance आप लोग को
Lordship, next week, tomorrow.
Item 28, DA152 of 2026.
Case diary and antecedent for this call. It has not been received. Written for Monday, 30.
Nobody argues on behalf of the petitioner. The counsel for the state seeks adjournment. He submits that the case diary and the antecedent report. Counter is also not. He prays for some time to apply the order dated 20/2/2026. Post this case on 30th March. In the meantime, office is directed to call for the present status of the trial.
Item 29, DA154 of 2026.
Aim to withdraw this petition.
Counsel for the petitioner seeks permission to withdraw this bail application. Accordingly, this petition
And-
is dismissed as withdrawn.
Appearance.
Next.
Item 30, DA165 of 2026.
Counter has to be filed by the party. That has not been filed.
This is
your
your
side.
side. Concerning advocate गिरी कुमार जस्टिस तो वो बोले कि हमको एक वीक का टाइम दें
Same order both
10
fees,
10 days
fees April के लिए declare. Same order.
10 days
Comply this order. Next. Counsel for the petitioner is present. And a counsel for the state prays for time to comply the last one.
Item 31,
In the meantime, office is directed over the
Stage of the case.
item 31, DA191 of 2026.
This came to last time, the state was asked to buy contract. They have bought.
Where is the case diary? You have filed your counter?
I have filed.
No. कल इसमें देते हैं सर इसको नेक्स्ट वीक करेंगे
अपाई करिए ना अभी. Also for the state files counter affidavit during court proceedings, which is taken on record. Case diary. He submits the case diary received by him to the court post tomorrow.
Tomorrow.
Yes. आपको जल्दी नहीं है? Wait.
He is asking for 1 week, कम से कम Friday को रखा जाएगा. कल छोड़ दिया जाए.
अच्छा आपको हड़बड़ी नहीं है?
एक दिन में क्या, 1.5 साल से जेल में, तो एक दिन में क्या अंदर होता है?
हम तो सोचे केस डायरी आ गया है, काउंटर आ गया है, अब कल आप
आज
ऐसा
आज लेने के लिए तैयार है. I'm ready for
तो फिर आज आर्ग्यू करिए. फिर क्या हम केस डायरी ना देखें, आज की बजाय कल कर लें.
ठीक.
चलिए हम केस डायरी खुद ही देखते हैं.
इस डायरी को इम्पैक्ट कुछ होगा नहीं.
अच्छा है ना, देख के पता चलेगा ना है कि नहीं.
हाँ, देख लीजिए.
देखिए.
कॉन्ट्रैक्ट में तो मालूम है.
कोई बात नहीं, हम केस डायरी खुद देखते
कॉन्ट्रैक्ट
हैं.
में तो
कोई बात नहीं.
होगा.
Under heading for hearing under order of 41 Rule 11 of CPC, item 59, second appeal 191 of 2018.
KSA number 191 of 2018. Nobody appears on behalf of the petitioner. On 15/1/2026, and no adjournment notice has been circulated. On 15/1/2026, the following order was passed. Thereafter, the case was taken up on 13/2/2026, on which day the learned counsel for the appellant had submitted that he had no instruction in the matter, and therefore appropriate petition in terms of order dated 15/1/26 has not been filed. The matter was adjourned by way of last indulgence and was directed to be posted on 25th of February 2026. And it was fixed for hearing on framing substantial question of law under Order 41/11. Today, the counsel for the petition is absent and no adjournment notice has been circulated. Accordingly, this petition is dismissed for non-prosecution.
Ladies out of time now. Out of time 6 cases. Item 51, second appeal 154 of 2024, along with item 52.
In this case, I have filed an ID for substituted service of notice on respondent number 1, 2, 4, and 6.
One, two, 4 and 6.
They are the only non-appearing respondents.
कहाँ के रहने वाले हैं
ये 1, 2, 3 तो इनके ही हम इतना बार नोटिस भेजे. They were with this appellant only. 1, 2, 3 इनके साथी they were the plaintiffs. हम 5 बार नोटिस भेजे. ये लोग इन्होंने भी कभी मुझे सही एड्रेस नहीं बताया. ये स्टे लेकर बैठे और they were same before.
IA number 3004 of 2026.
They are the two landowners, my lord.
In SA number 154 of 2025. The counsel for the appellant has submitted that the petition has been filed for substituted service of notice upon respondent number 1, 2, 3, 4 and 6. He has also submitted that in spite of best of efforts, the appellants could not secure their appearance. He has further submitted that एक कोई महाराष्ट्र का एड्रेस है,
एक respondent number 2,
एक चेन्नई का एड्रेस है.
Actually, they are all one and same. Landowners are सब same ही हैं, sisters and brothers.
एक पावर ऑफ अटॉर्नी तो ऑल परमानेंट रेजिडेंट ऑफ क्यों लिखे कोलकाता?
This is the main claim. सारा वही है your ladyship. In the main claim, in the appeal, this was the thing which I quoted, and they were the plaintiff before the court.
Okay, they have all given the permanent residence at Kolkata.
Yes, that is there in the.
Madam, respondent number 6, Liaq Ahmed, is the person who is having power of attorney from whom this appellant has got the title. As per.
He is in Hazaribagh.
He is in Hazaribagh.
Yes.
Okay, the learned counsel submits that as per the plaint, respondent number 1 to 4 have permanent residence at Kolkata. And so far as respondent number 6 is concerned, he is a resident of Hazaribagh. He submits that appropriate order may be passed for publication of, for service of notice through newspaper publication having circulation at Calcutta and Hazaribagh. Considering the aforesaid submissions, the prayer for substituted service of notice is allowed. The counsel for the petition is directed to is allowed, and through the for service of notice through newspaper having circulation at Calcutta and Hazaribagh, that is Telegraph.
वाइडली सर्कुलेटेड अपने जो भी हो रहा हो
टेलीग्राफ ने ऐसा नहीं, वो ऑर्डर में करना होता है। टेलीग्राफ एंड प्रभात खबर का भी सर्कुलेशन।
प्रभात खबर इन हजारीबाग एंड टेलीग्राफ
नहीं, टेलीग्राफ एंड हजारीबाग फॉर रेस्पॉन्ड नंबर 1 to 4 and 6।
इन हजारीबाग इन कलकत्ता 1 to 4 इज देयर।
एक ही बात है ना, आप उसमें एक और आदमी ऐड कर देंगे। इट्स सिंपल, जब करना ही है तो ये दोनों सबका करना। इन टेलीग्राफ एंड प्रभात खबर having circulation in Kolkata and Hazaribagh. The draft notice for publication be furnished by the petitioner in the registry within a period of 1 week. 1 week from today. The registry is directed to hand over the notice to be published to the petitioner, the counsel for the petitioner within a week thereafter. The supplementary affidavit annexing the newspaper after publication be filed by 24th April. By 24th April. Post on 4th of May. Okay. Post on 4th of May. In essay number 153 of 2018, the interim order passed earlier is extended till 4th of May. इन दोनों का कॉमन ऑर्डर ही करेंगे।
Item 60, 2nd April 87 of 2023.
आगे प्रोपोजल
Counsel for the petitioner prays for Passover by submitting that the arguing counsel is in court number 3. चल रहा है court number 3. Is on legs in court number 3. Goes tomorrow. Next.
Item 61, 2nd April 232 of 2023.
टाइम खाली मांगने के लिए आप लोग खड़े हो जाते हैं। नहीं, पिछली बार भी आपको नेक्स्ट डे के लिए आपका प्रेयर था, अब भी एक्स्ट्रा टाइम counsel for the petitioner seeks adjournment by way of last indulgence post this case tomorrow.
Item 62, 2nd April 139 of 2025.
Sorry? Who will argue this case? I hope he argues. That should not be a reason for when you are seeking adjournment on the ground of a senior counsel. Then on the next day, ऐसा नहीं कि आप कोई भी आकर खड़ा कर देता है, तो उन्हीं को बहस करना होगा ना, because on this ground you are seeking adjournment. 21.
Immediate next.
Is out of station. Essay number 139 of 2025. The counsel for the petitioner appellant seeks adjournment on the ground that Mr. A.G. Sinha, advocate, is out of station. At a request, post this case on next Tuesday, the supplementary processed.
Item 63, second appeal 1 of 2026.
May it please your lordship. Lord, the appellant here, Lord, is the plaintiff, the daughter, under the Muslim law, Muslim Hanafi law. And this plaint was filed, Lord, for allotting or partition and then allotting her predefined share, Lord, under the Hanafi school of law. Under the Hanafi school of law, Lord, it is predefined. उसमें चार्ट बना हुआ है और डॉटर को हाफ मिलेगा, वो predefined वगैरह है. Now both the courts, Lord, simply because in the plaint jointness, the defendant number 1 in this case, Lord, is my brother, full brother, uterine brother, from one father and mother. Now, both the courts, Lord, agreed, held that there had been no earlier partition. And contrary to this finding, now the appellate court, Lord, he said that there is no concept of jointness in the Muslim law. And since in the plaint you have pleaded jointness with the brother, and therefore, Lord, they dismissed my plaint and the suit. Only on this. I will place, Lord, the relevant paragraph of the appellate court, Lord. What the appellate court says is that finding at page 26, para 20, Lord, I will place, in which it is said that the plaintiff failed to prove that such and such part of the property falls in her share. तो ये हम कहाँ से बता पाएंगे कि कौन कौन सा पार्ट मेरे शेयर में है? हम तो अलॉटमेंट के लिए आए ही हैं कि पार्टीशन करके हमको कौन कौन सा मेरा पार्ट होगा शेयर करके वो हमको अलॉट कर दीजिए. So now this finding he failed to, may I place that page 26 of the appellate court. Page 26, Milord, running page 39. Further, in the light of the law settled by honorable courts in the judgments above mentioned, and the custom prevails in the Muslim community, when I see the pleadings and evidence of plaintiff, and find that nowhere, neither in oral evidence nor in documentary evidence, sorry, the plaintiff has succeeded to prove.
We need to rise.
Pardon?
We need to rise. DBA.
No.
Post over. The matter could not be concluded post over.